Colleagues, good afternoon. I call to order the meeting of the Bills Committee on Post-Secondary Colleges Amendment Bill 2025. I need to first consult members on one thing, whether we need to elect a deputy chairman. All right. If no one asks for this, we will not proceed with the election of the office of deputy chairman. Let's first invite representatives of the administration to come inside the conference room. I have communicated with the relevant officials for ease of understanding of members. The administration has prepared an information paper on the salient points of the bill. The paper number is LC paper number CB brackets 3432/2025 brackets 01. The legal advisor has also issued a letter to the administration to ask some questions on the bill. The paper number is LC paper number CB brackets 3428/2025 brackets 01. We're awaiting response from the administration on the letter. We'll ask representatives of the administration later whether they will provide an oral response now or just a written response later. We will first discuss the policy matters on the bill. Before we go into discussion on the policy-related matters, I need to ask members this. Are we going to invite written submissions from the public on the bill? What are members' views on this? First of all, actually, should we hold a public hearing? If not, we'll just post a notice online inviting written submissions from the public. Okay? We will not hold a public hearing. We will post a notice on the LegCo website to invite written submissions from the public. Once we've received the written submissions, we will forward the submissions to the administration for them to give a consolidated response. All right, on to meeting with the administration. I'll first ask representatives of the administration to brief members on the bill. I will also ask members to press the request to speak button to indicate their intention to speak. I'll assign a 5-minute time limit for members to speak to give everyone adequate time to speak. And I may allow for a second round of questions. Secretary, when you're ready, please brief members on the bill. Thank you. Education is the key to nurturing talent and building a strong nation. The self-financing education sector is a core part of the education system. All along, they have the advantage of being flexible. The government has been providing the sector with support for them to develop in parallel with the public-funded education sector. We have recently published an education plan in the country, and an important part of it is to develop the education sector. The Post-Secondary Colleges Ordinance, Chapter 320, was enacted in 1960 without any major reviews since then. It's inadequate to support the healthy development of the self-financing sector. Upon extensive consultations, we propose to amend the ordinance, and this is the right timing to tie in with national education policies to reform the regulatory regime of post-secondary colleges to enhance their capacity and quality so that they can make better contributions to a strong education nation. I will now talk about the propose amendments to the ordinance and the aims. There are 3 objectives. 1, to enhance governance structure and to enhance accountability. 2nd, to relax restrictions to enhance effectiveness and efficiency. 3, to put in place a unified regulatory framework to ensure consistency in the regulatory regime for the self-financing sector. I will now talk about the salient points of the bill on enhancing governance structure. In order to respond to public expectations of the self-financing sector, we will enhance the governance structure requirements and make sure the requirements would ensure the quality of the academics and administrative arrangements of the colleges to make sure they can align with the current standards for tertiary education. We have also advocated for good governance of colleges. We also want to make sure there is transparency of the policies of the self-financing education sector and to ensure the teaching personnel are up to par. We need to make sure we are putting in place an effective learning environment for students. We want to say again that we will not have unified targets for student intakes. We would allow for specific assessments to be made on an individual institutional basis. And the relevant institutions must maintain an institutional review status obtained from the HKCAFQ. With this arrangement, it should ensure the standards of colleges to be on par with UGC-funded universities and international institutions. That should enhance recognition of the colleges. And this would ensure parallel development of the self-financing education sector and the publicly funded education sector. We also want to enhance accountability of colleges. The colleges would have to submit annual reports and strategic plans to the Education Bureau regularly. They would also need to publish abstracts of such documents and their key financial information for the public's reference. In Chapter 320, in some of the provisions relating to powers, for example, for the cancellation and suspension of registration, powers will be conferred to the Secretary for Education. The other powers will remain vested with the Permanent Secretary for Education. And this approach is in alignment with the general approach of the government. The Permanent Secretary will continue to be responsible for their powers to the Secretary for Education. We will also set a comprehensive set of procedures to enhance the standards of colleges. Under the new mechanism, the Education Bureau can ask colleges to give explanations and rectify certain situations. The Education Bureau may also impose requirements or conditions. If colleges do not rectify the situation in time or do not comply with the relevant requirements or conditions, the Education Bureau may cancel their registration. And the Education Bureau may also impose restrictions on the teaching out of colleges to ensure that the students and teachers can phase out in an orderly manner. We also require registers to be maintained for relevant members on boards and the teaching personnel so that we can maintain the statuses of the relevant personnel and cancel registration if necessary. We will promulgate administrative guidelines on the relevant arrangements. We will also add some offense-related provisions to deal with those who have not registered under Chapter 320 and thus breaching the relevant provisions to be punished. We will also relax certain restrictions. We will rationalize the various regulatory arrangements under Chapter 320. We will also repeal the obsolete provisions to enhance flexibility for the colleges and nurture talents for the city. We will also streamline the governance structure requirements from 4 tiers to 2 tiers. The Board of Governors will be the topmost governing body, and the academic board will be regulating academic affairs. We will remove the restrictions for requirements for the board, the college council. We will also repeal other obsolete provisions in order to better coordinate the self-financing education sector and to make sure we can help the self-financing educational institutions develop their niches. We will confer the power of the award of degrees from the Chief Executive in Council to the Secretary for Education, and the Secretary for Education can have reference to manpower requirements and the past experience of institutions, grant award of degrees, and the institutions may lodge appeals if necessary. We will also confer other powers of the Chief Executive in Council to the Secretary for Education for better coordination. We right now have 11 institutions registered under Chapter 320, including 3 private universities. But other institutions, including the self-financing arms of institutions, of publicly funded institutions, as well as schools registered under the Education Ordinance. Chapter 279 actually regulates primary and secondary education. It does not provide for an appropriate regulatory framework for tertiary educational institutions. And the self-financing arms of publicly funded tertiary institutions are only subject to regulation of their parent institutions. So there is room to enhance governance and transparency. Therefore, we propose to have a unified regulatory framework for tertiary education institutions operating degree level and sub-degree level programs. I want to say this. We will not, by law, make the self-financing arms and the schools automatically transition to 320. We will, however, provide support for the institutions to register under Chapter 320. Also, this bill will come into effect 1 year upon passage of the bill. It should give enough time for schools to get a better understanding of the provisions, and there will be another 2-year transitional period, that is 3 years after the passage of the bill. This should allow for ample time for the institutions currently not registered to complete the registration procedures. We have consulted the relevant bodies and stakeholders. We are very happy to report that in general people were supportive of the proposed amendments, and the amendments that we're proposing now have struck a balance and incorporated feedback from stakeholders. We have also tabled the relevant information paper and our LegCo brief before members. I urge members to support the bill, and I'm more than willing to answer any questions of the members. Thank you. Chair.
Many members have pressed the button. I will read out their names. First, Dr. Johnny Ng, Mr. Rock Chen, Reverend Peter Kun, Mr. Lam Chen Singh, Mr. Tang Fei, Professor Lau Chipang, Mr. Lai Tong Kwok, Ms. Carmen Khan, Mr. Chow Man Kwan, Mr. Dennis Leung, Professor William Wong, Professor Priscilla Leung, and Dr. Starry Lee. Each member will have 5 minutes, including question and answer. First, Dr. Johnny Ng. Thank you. I have to declare interest. I am a member of the Board of Directors of the Baptist University. This amendment comes at a very right time, and we are now trying to turn Hong Kong into an international hub for high caliber talents. We have started the consultation for this bill 5 years ago. The education sector is well aware of this bill. I support it, and I think that by having this bill, we can remove barriers and make everything more consistent, and it will allow Hong Kong to attract more diversified talents. I have a few questions for the Secretary. First, on a cancellation of registration, paragraph 10 of the paper says that we're going to establish a fair and transparent mechanism for canceling the registration of underperforming colleges. Well, deregistration is a very serious penalty. I wonder under what circumstances would the colleges have their registration canceled? Can you give us some examples? Apart from issuing notices to Board of Governance to ask them to make explanation, is there a workflow on the cancellation process? Is there a time limit for the board to rectify their actions? The bill sets out some offenses. A person who acts as a member of Board of Governors, President, Vice Presidents, or teacher of a registered college, if the person is not registered or the person's registration is suspended or canceled, will be fined $250,000 or imprisoned for 2 years. If anyone provides false or misleading information in relation to application or does not comply with the requirements imposed by the Permanent Secretary, will be fined $250,000 and imprisoned for 2 years. This penalty is rather harsh. A jail term is involved. I wonder if you think that the penalty is too heavy, what factors did you take into account before deciding on the level? Thank you. Many questions. Now, I will allow the Secretary time to answer all of them. If you cannot answer all of the questions, you can reply in writing. Thank you. On the point about cancellation of registration, it is a serious penalty. So we act cautiously when we decide to cancel the registration, and we will not exercise such power lightly. There is such a provision on the cancellation in the existing ordinance. But under this bill, we try to set out the workflow and provide for clearer requirements. So in paragraph A, it says that we are going to set out the fit and proper criterion for staff, and the number of students being admitted should be sufficient to provide a meaningful learning environment and experience, the legality of its operation, the sustainability of the colleges, so on and so forth. Also, the college should attain and maintain a institutional review status from the Hong Kong CAAVQ, along with institutional capabilities. We try to set out new and enhanced specified requirements in the bill. As for examples, we look at each and every case on an individual basis. When we detect a non-compliance or suspicious non-compliance with regulations or requirements, the Secretary will inform the Chairman of the Board of Governance of the college, asking them to provide explanations and rectify the circumstance. The Secretary may also impose conditions or restrictions on the college. So there is a communication mechanism in place. After the college has received the notice without rectification, the second step will be invoked. There may be further conditions or restrictions imposed on the college. The entire process is very transparent. Second, on the penalty level of the offenses, I will see if the senior assistant law draftmen have anything to add. We've made reference to other education-related ordinance, including the education ordinance. Offenses include false or misleading information. All these are legal acts. When this happens, we may suspend the registration. If someone continues to act as a teacher despite having their registration suspended, this will be an offense. So we have regards to the gravity of the offense and set different level of penalty. We have made reference to similar ordinances. What about the appeal mechanism? It's also set out in the paper. If the college are aggrieved by the, say, program-related decision, they can lodge an appeal to the Chief Secretary for Administration. As for the registration decision, they can appeal to the Chief Executive in Council. I'd like to ask about the penalty level. Let's see if there's any legal advice from the DOJ. Thank you. Regarding the offenses and penalty level, as mentioned by the Secretary, we have made reference to similar offenses and penalty level under the Education Ordinance. Under Section 87 of the Education Ordinance, similar offenses are provided for, such as continuing to act as a teacher despite having the registration suspended or canceled. The penalty level is similar to those set out in the Education Ordinance. Johnny, do you have anything to add? Any follow-up questions? No. Mr. Rock Chen, please. Thank you, Chairman. I have to declare interest. I am the chairperson of the Hong Kong CAAVQ, and I am also a member of the Board of Governance of the Hong Kong U. The Secretary said that there are 3 policy goals to this bill. I support them, but I have 3 questions. The Secretary talked about the 3 goals. I believe that the community will support it, but some post-secondary colleges are worried if the bill will bring about challenges to their operation because they later will have to have their courses approved by the Hong Kong CAAVQ, and they have to disclose some key financial information to the public for scrutiny. So I wonder how can we support the development of post-secondary colleges while meeting the public expectations for high-quality post-secondary programs. Second, the self-financing arms of publicly funded institutions will fall under or within the scope of the unified regulatory regime. and you're going to amend also the education ordinance. I know that the self-financing arms of publicly funded institutions are prepared to register under CAP 320. I wonder how the administration can support the self-financing arms in transitioning to CAP 320. Chairman, I noticed that there is no reference to vocational and professional education requirements under CAP 320. So I wonder how we can continue to support the development of VPET in Hong Kong upon amendment to CAP 320. Secretary, thank you. As for the challenges that the post-secondary colleges will face upon amendment and how we're going to support them, well, first, we will set out clearer requirements on the quality of programs while relaxing some of the barriers to allow colleges to enhance their efficiency. Say, for example, the 4-tier governance structure will be streamlined to 2-tier so that the colleges can enhance their efficiency in terms of their management and operation. Now, in terms of support measures, we actually have a package of measures such as the land grant scheme, startup loan scheme, matching grant scheme. Also, we all have a study subsidy scheme for designated professions sectors for students. They will enjoy the SSSDP and the non-means tested subsidy scheme for self-financing undergraduate studies in Hong Kong. So at the institutional level and student level, we offer many different subsidies, schemes, and grant schemes. We will have regards to the situation of individual colleges to help them migrate. In terms of timetable, as we mentioned, we're going to have a total of around 3 years of transitional period. We will also have other measures to help colleges transition. We provide facilitation measures in terms of institutional review and accreditation status. Self-financing sector plays a very important role in the education sector. Under the pilot scheme for applied degree program, we have gained some experience. We have established some standards for the development of applied degree programs. This is important. And last year, riding on this experience, we have universities of applied science. We have 2 of them. Under CAP 320, for self-financing institutions, if they want to become UAS, they can apply to become such while they're applying to become a private university. So this is how we enhance the image of VPET in Hong Kong while we support the development of self-financing institutions in Hong Kong. Thank you. Reverend Peter Kun, please.
Thank you, Chair. I would like to declare that I am on the Board of Governors of Gracia Christian College. With post-secondary colleges, they have to maintain an institutional review status of the HKCAVQ. and this is to be maintained in the long term. I wonder how it works in operation. Also, with the approval courses, the approval process right now is quite long. How can we streamline the process upon passage of the bill to facilitate the establishment of degrees by colleges? I note that in the provisions there are multiple provisions on powers. From what I understand, there are only 2 powers relating to the Secretary for Education. It's just registration and deregistration of colleges. Other powers would be vested with the Permanent Secretary for Education. I note in many recent bills we would have catch-all provisions. So can we have a catch-all provision that would have the Secretary for Education give directions to the Permanent Secretary and other appropriate officers? I think this approach would be more appropriate because this will allow for a catch-all provision. This ordinance may be older, that's why it probably doesn't have this. When we scrutinize recent bills, such as the bill for social workers registration and protection of critical infrastructures, they all have similar provisions. Thank you. Secretary, we do see that there are many powers of the Secretary for Education. Can you respond to Reverend Peter Kuhn's question on whether there may be provisions that will allow you to give directions to Permanent Secretary? Thank you. Sure, Chair. On how in operation we would require maintenance of the institutional review status. We actually have reviews of the statuses regularly, and we would engage overseas and mainland experts to undertake such reviews to ensure the quality of education provided by the colleges. Before self-financing courses would have to be approved by the Chief Executive and Council. We understand that with the establishment of courses, they would first have to go through some committee reviews, but the reviews would take different times to undertake the reviews, and then the findings would have to be submitted to the Chief Executive in Council for consideration. So the process is indeed quite long, which is why we're proposing to have the power conferred to me instead, so that we can deal with the approval relatively quickly. This should enhance the speed of establishment of qualifications by the colleges. As for manpower or the distribution of work, we have 5 aspects of powers for the Secretary for Education to impose conditions and restrictions on colleges, registering colleges, deregistering colleges. That is a form of follow-up action. We also have some powers relating to the award of degrees. The principle is this: to distribute work between the Secretary for Education and the Permanent Secretary. We try to have reference to the proportionality of the responsibility to the position of secretary or permanent secretary. We had reference to the distribution of work in other bureaus and departments. So for the high-level steering, it would be undertaken by me. As for implementation, these powers are conferred on to the permanent secretary. This is the overarching principle. Reverend Peter Kuhn asked if some of the powers may have been missed in the drafting of the provisions. We will definitely review the drafting and consult the DOJ for advice to see if there's any need to make revisions. I think Reverend Peter Kuhn can specifically raise some powers that you think that should be vested with the permanent secretary and mention this. Chair, I think it's the other way round. I think we need a catch-all provision to catch any powers that should be vested with the Education Bureau. And of course, I can liaise with the relevant officials in due course if I remember anything. After all, the secretary should be made accountable to the relevant work. So we'll deal with it after the meeting. Thank you. Mr. Lam Chen Singh, I understand that there are other schools operating self-financing programs that may need to be registered under Chapter 320 upon passage of the bill, and they may be of a considerable scale. They may already be operating programs in collaboration with some departments, say the police force, and they should be able to pass the institutional review. But how can the Education Bureau support their transition onto registration under Chapter 320? Can you perhaps streamline the procedures to help them better transition to registration under Chapter 320? Upon passage of the bill, I believe the self-financing educational institutions should be able to admit more non-local students. I think right now there are some inaccurate reports on social media, say Xiaohongshu, saying that they only need to study for 1 or 2 years and then they would be awarded degrees from self-financing educational institutions. We, of course, need to prevent abuse of the mechanism. How can we better regulate programs of the self-financing education sector? How can we make sure we put in place some qualification requirements and make sure the qualifications would meet the future manpower needs of society? We shouldn't have people abuse the mechanism as an avenue for them to migrate to Hong Kong. Once we can ensure the quality of the programs, is the Education Bureau confident to strive for support of the central authorities to admit more non-local students for self-financing educational institutions? Thank you. Secretary, whether we will have support measures for the transitioning of institutions. Chapter 320 would be regulating institutions operating degree level and sub-degree level programs. We have 7 institutions currently registered under Chapter 279. We also have some self-financing arms of 5 publicly funded tertiary institutions. We also have 11 institutions that are currently registered under Chapter 320. So for in future, we will have a number of institutions to be regulated under Chapter 320. And for those who are transitioning to registration under Chapter 320, we will enhance communication with these institutions. We will also, with reference to actual circumstances, streamline the relevant institutional review procedures upon discussions with the HKCAPQ. The institutional review will also be made with reference to the different circumstances of the institutions. please rest assured we will definitely enhance support for the relevant institutions. We all along attach great importance to education quality of the self-financing sector. We require students admitted must meet the admission requirements of the institutions. We also have clear requirements for the quality of students admitted as well as the programs operated. With the establishment of qualifications, before we have institutions go to Hong Kong CAVQ, we ask institutions to develop their niches to meet for one future manpower needs instead of operating similar programs. This is what we plan on doing upon passage of the bill with the powers of the Secretary for Education granted to me. We also want to make sure that institutions with enhanced quality through administrative arrangements with central authorities, we can perhaps enhance admission of mainland Taiwan and Macau students to increase the quota. Perhaps we will work with the Ministry of Education and we will continue to communicate with the central authorities. Apart from mainland Taiwan and Macau students, other overseas students are not subject to any restrictions, as a matter of fact. And the quota imposed on mainland Taiwan and Macau students are only imposed on undergraduate qualifications. For postgraduate qualifications, there are no restrictions. Thank you. Mr. Tang Fei, I support the amendments to be made to Chapter 320. We have been waiting for them for so long. I have some suggestions. One suggestion is echoing on the point that Reverend Peter Kuhn made. We want to say this for the work of education. It is important work. It is not just about the division of work between the secretary and permanent secretary. I think we should have a provision that would have the secretary issue directions to the permanent secretary if necessary, or other officers that would have to implement Chapter 320. Next, upon passage of the bill, there may have to be some administrative arrangements to support the institutions. Let me take primary and secondary schools as an example. We would have under regulation of Chapter 320 some tertiary institutions or self-financing arms of the publicly funded tertiary education institutions, but we also have schools currently registered under Chapter 279 or some community colleges. But this can be complicated because they may be renting land under Chapter 279 as community colleges. And if they are regarded as another kind of private universities, there may have to be new land grant terms. They may have to be treated as self-financing universities, tertiary education institutions, and they may be regarded as a tenant instead. This may involve other government departments. Are there any administrative arrangements that would help with the transition of the colleges in this regard? Because it may involve other departments. Will you set up, say, cross-departmental teams to help them transition?
Secretary, thank you. As mentioned, we amend CAP 320 to enhance the quality of the programs offered by self-financing institutions. I know that there are institutions offering sub-degree programs under CAP 279, These institutions may be offering courses under CAP 279 and CAP 320. We have regards to the actual circumstances of individual institutions. If there are problems with, say, lease conditions, we will talk to the institutions directly because they are subject to different lease conditions. If they need our help, we will talk to the relevant policy bureaus and departments so that we can amend the lease conditions so that these relevant colleges can continue to serve the community. What about the tenancy agreements? Are you going to be flexible? Some tenancies agreements set out the types of programs that can be offered by the institutions, so we have to look at each and every agreement individually. The Education Bureau will help the colleges make amendments, and we may help them in talking to other government departments and bureaus. Next, Mr. Lao Shipang. Thank you. I have to declare interest. I am a member of the publicly funded universities, and I am also a member of the Council of a self-financing institutions. Will the cancellation of registration of a college take effect immediately? Because in the past, there was a case where a college was registered and all the teachers and students have to leave immediately. The Secretary of Education will decide on the cancellation, but are we going to have a transitional arrangement for the teachers and students in case that the appeal application is in vain? Second, I definitely support the Post-Secondary Colleges Amendment Bill 2025. After passage of the bill, are all colleges registered under CAP 320 of the same caliber or level? Because all of the programs would have been assessed by these Hong Kong CAAVQ and they would have been registered under the CAP 320. While we are trying to develop ourselves into an international post-secondary education hub, so is it the case that the institution, regardless of their scale, will be of the same level? Will they enjoy, therefore, the same kind of treatment? If an institution offers 3 courses only, will they enjoy the same ratio of mainland students compared to those offering 30 courses? We don't want to see any differential treatments. The government offered the same level of subsidy to all UGC-funded universities, for example. Secretary. Thank you. If colleges don't meet the requirements under paragraph 8 and the secretary after asking them to rectify and explain the circumstances and they fail to do so, we will have to invoke the deregistration process. We know that deregistration will impact stakeholders, students, and teachers, so the permanent secretary will be empowered to impose conditions and restrictions on the college to make sure that there was a smooth teach-out in the public interest and best interest of affected students. Before cancellation of registration, the secretary will ask the colleges to provide explanations and rectify the circumstances and or impose conditions or restrictions. We stress a smooth teach-out process. For immediate teach-out, it could involve serious non-compliance, But as for the process of deregistration, it's set out very clearly in the paper. All of the institutions under CAP 320 will be of the same level and treated the same way. We have different requirements on the programs, but the entire workflow will be the same for all of the institutions and colleges. But we have different requirements on the types of programs. Say if they are a sub-degree program or degree program, we're going to impose different requirements. The colleges should enroll the number of students in accordance with their mission and goal. If the number of students enrolled meet their strategic goal, then we may consider them in compliance with the requirements. On recruitment of non-local students that are mainland Macau and Taiwan students, we try to impose the same ratio on all institutions. We are still talking to the mainland authorities. They have their own considerations. Previously, there were 6 self-financing institutions have, say, 60%, some have 20% of Macau, Taiwan, and mainland student percentage. Upon review, the 6 self-financing institutions enjoy, say, a 40% of non-local student quotas. As our self-financing education sector enhances their quality, we believe that we can raise the ratio even further. There is certain flexibility for some institutions regarding the 40% cap. Is that right? Yes. We hope that the institutions will not exhaust all the 40% cap. They have to have regards to their teaching capacity, their facilities. Thank you. So upon enactment of the bill, not all self-financing post-secondary institutions will enjoy the same ratio of non-local students. It seems that the Secretary is not confident in this regard. Well, this bill is quite a breakthrough. Can we use this opportunity to allow self-financing institutions to enjoy the same percentage across the board, regardless of their scale? I think that upon amendment of the ordinance, we should align the ratio across all self-financing institutions. If you need the support of the trade, we will offer assistance. Secretary, thank you. Yes, this is our goal. When we try to raise the ratio of non-local students in publicly funded institutions, we try to align the percentage across all self-financing institutions, just like what we do with the publicly funded institutions. As the self-financing institutions continues to enhance their quality, we believe that we'll be able to align the percentage in the future. Next, Mr. Lai Tong-kwok. Thank you, Chairman. I speak in support of the Post-Secondary Colleges Amendment Bill 2025. The administration has conducted extensive consultation, and we have talked about this bill multiple times in the Legislative Council. The administration said that they have suitably incorporated some of the comments of the community. I'm concerned about the amendment to Section 6 of the ordinance, that is, the statutory power. In the original ordinance, there are two parts to the statutory power. Some rest with the Secretary, some rest with the Chief Executive in Council. In the proposed amendment, there will be clearer delineation. For deregistration of colleges, the Secretary of Education will exercise such power. For permanent Secretary for Education, he or she will only exercise administrative-related power. Under proposed Section 6G of Cap 320, the permanent Secretary is empowered to engage public officers to handle the relevant process on their behalf. For the Chief Executive in Council, their power will remain the same. There will be a committee to assist the Chief Executive in Council in scrutinizing or coming up with the decision. I have some suggestions for the Secretary. We all know that we have an accountability system. As the head of a policy bureau, the Secretary should have the final say. In other words, the Secretary has the ultimate responsibility and the power Now, the power to register and deregister a college is going to be vested with the Secretary for Education. I think that this is the right way to go, but administrative system is one thing. In the course of invoking Cap 320, very often the functions are exercised by the permanent secretary or the public officer appointed by the permanent secretary. I think that there would be things that needs to be discussed between the permanent secretary and the secretary. So I hope that the secretary will offer advice to the permanent secretary or the public officers appointed, or perhaps give them direction. If this is the case, then the law can be implemented more smoothly. Just now, some members talked about a suggestion. That is, whether we should introduce a provision under the ordinance to empower the Secretary for Education to give directions or directives to their colleagues. I fully support this suggestion. I could give you two examples to illustrate. Under Section 52 of the Immigration Ordinance, the director is empowered to give directions to immigration officers. We have just passed the Critical Infrastructure Computer Systems Bill. The Secretary for Security has incorporated the members' views by adding Section 68A so that the Secretary can give directions to the commissioner or public officer appointed by the commissioner. I'm not trying to tell the secretary what to do, but I think that under certain circumstances, the secretary should be empowered to give directions or advice to their colleagues in order to carry out the duties at hand. So I hope that the secretary will consider this.
Secretary. Thank you, Chair. I note the suggestion and concern raised by Mr. Lai, we would say this. We would have reference to the policy intent. We will review the drafting and consult the DOJ, and we will report to members in due course. Ms. Kamen Khan. Thank you. I speak in support of the amendments proposed by the Secretary for Education to post-secondary colleges ordinance. If we are to develop into an international hub for post-secondary education and an international hub for high-caliber talents, it is necessary to make changes. I'm not from the education sector, but I've heard members in the education sector speak. I am also very concerned about the direction that the education system is developing in. We understand that with the passage of the bill, with the regulatory regime in place, it will weed out some of those who are underperforming. And this is sad, but this is also important in ensuring quality to build a strong education nation. I would say this. I understand what is said in the information paper, that we have some powers transferred from Permanent Secretary to the Secretary for Education. Only powers of implementation will remain vested with the Permanent Secretary. We have colleges that would have to, say, be held accountable. I understand that the Secretary has the powers for registering and deregistering colleges, but for the power of personnel registration, it remains with the Permanent Secretary. I would say this. For the Protection of Critical Infrastructure Bill, I actually made a suggestion that would enhance accountability by giving power to the Secretary for Education to issue directions to the Permanent Secretary and other officers if necessary. I'm sure Mr. Salvador Zhang would know because he was also there when we were scrutinizing the Protection of Critical Infrastructure Bill. And I think once we agree on the general direction, we will not have to dispute each and every power in the bill when we go into clause-by-clause examination. So I would urge the administration to review this suggestion. It would also demonstrate that the Secretary would give high-level steering by vesting with the Secretary such powers. Next, I want to talk about the transitional arrangements, or let me say, for the regulatory regime. I agree that there should be a unified regulatory framework for the self-financing sector, and the HKCAFQ would be reviewing the operations of the colleges, and especially with the awarding of degrees. But we also have some self-financing arms of UGC-funded education institutions, say the Hong Kong U Space or PolyU Speed. They are institutions of different scales. Some are actually incorporated. When the institutions are of different scale, how can you ensure there is proper transition for different institutions? What kind of support can the Bureau give to institutions of different scale? If time will allow, I will ask a second round of questions, Chair, just for your reference. Thank you. Secretary, we do note the suggestion on a potential catch-all provision for the power for the secretary to issue directions. We will review the drafting and report to members in due course. As for institutions of different scales, how can we provide support to them in their transition? For the smaller scale institutions, they actually consider moving back towards their parent institutions, essentially being subsumed under their parent institutions, because they can then focus on academics and research. So for these smaller scale institutions, they already have such plans to be subsumed under parent institutions. This is one way. For the larger institutions, they are inclined to register under Chapter 320 later. That will facilitate them because they will no longer need to promulgate 3-year plans. They do not need to undergo strategic coordination. There will essentially be some looser regulation through boards or other councils. If these schools or institutions are to register under Chapter 320, they will need to go through registration and some approval procedures, but we will give them ample time. As I said earlier, we will give them in total 3 times upon passage of the bill to transition. For institutional reviews, we would also have reference to their past experience, coordinate with the HKCA AVQ to put in place some facilitation arrangements to help with their transition. So it would not be an automatic transfer, but with reference to the institution's past experience, we can perhaps put in place some facilitation arrangements to help them with their transition. Thank you. Professor Chow Menkong. I am an employee of a UGC-funded institution, and I am also a member of a self-financing educational institution. Since its enactment in 1960, it is the first major review of the post-secondary colleges ordinance. I think the amendments would help us keep abreast with the times, so I support the proposed amendments. But I would say this, for Chapter 320 amendments, there will be an impact on the self-financial education institutions. There are 7 institutions registered under Chapter 279, and so in total there will be at least 21 institutions that will be regulated under Chapter 320 in future, and the students that may be affected will be 50,000. That is quite a large number, and we should pay close attention to the potential impact. I have some questions for the Bureau. We would have some schools that are to transition to registration under Chapter 320, and in fact, a professor under PolyU Speed expressed in a recent media report that they would have more sub-degree programs and master's programs under the institute. With the registration under Chapter 320 done, they will be registered as a private university in 3 years. It seems that they are already speaking in concrete terms, and this has been debatable. So for these self-financing arms of publicly funded institutions, we need to think about their assets. We also need to think about the names of the colleges. How can we also ensure the quality of the qualifications? First, on the colleges that are self-financing arms of publicly funded UGC funded institutions, since they are to be independent, can they still name themselves as part of their parent institutions? Say the City U actually had a self-financing arm, they have transferred it to the University of Wollongong, and now it is called the University of Wollongong Hong Kong College. It is no longer relevant to the City U, as the name suggests. And according to the national and Guangdong standards, say for a particular university in China, the Sun Yat-sen University, they actually also have a self-financing arm with their independence. There is also a change of name. So if we adopt an approach that would allow the colleges to keep their names upon independence, I think it is worrying. Also, with self-financing institutions, there are varying degrees of quality. First, you would have to go through a FEQ test of the HKCAA FEQ, and it would take at least 2 to 3 years to complete the process. And if you have to obtain other PAAs, the process would be even longer. But I gave you an example. Someone from the institution said there would already be 100 qualifications established before they are independent from their parent institutions. So I first want to ask the Bureau, will you approve this application of the 100 qualifications, and then they can immediately become a self-financing university? This has a great impact on other self-financing institutions. It is very unfair to them because it would be a sliding victory for that particular institution, right? To have all these qualifications already set up. Will this institution undergo review again after their transition? How can we prevent them from establishing the qualifications before they transition so as to prevent circumvention, so to speak? How many more questions do you have? Because you have gone past the time limit. If you only have one more question left, I will let you ask the question. I can ask in the second round then. All right, please pause here then, Secretary. Thank you. I'll answer the first two questions. On the self-financing arms of UGC-funded institutions, there are 3 institutions that are planning to register under Chapter 320. The member is concerned about the naming of the colleges. We have been very clear. If there is the word university in the name of the college, it would require approval from the Chief Executive and Council. If they are just saying that there is a relationship between the parent institution and the self-financing arm, say for the associated primary schools of some organizations, they would say that. And I think people are often clear about the relationship. I guess it's just about creating a brand, but we would emphasize that this should not be misleading the name. And as I said, that there may be procedures that they have to go through if they have to name their colleges a certain way. As for the review of qualifications, the qualifications will not transfer automatically. They need to pass the review arrangements of Chapter 320. But as said, we will have reference to the past experience of the institutions. We will work with the HKCAA FEQ to flesh out arrangements that would provide more convenience to the institutions, but we will not compromise on the quality. It's just that we do not want to raise resources on repeated procedures. The member asked about when institutions opening many degrees or establishing many new degrees. We actually note the situation. For the self-financing arms of these UGC-funded institutions, in the past year, they have actually had less courses than before. So we do not see institutions establishing new qualifications by a significant amount with the preparation of this bill. I think Professor Chow Man Kong talked about other issues as well.
Regarding the institution or college just that the member just talked about, the establishment of the self-financing arms should be approved by the Board of Governors of the university. Some staff members of university may have their own views, and I believe that the relevant universities have published a statement to clarify the situation. If a publicly funded institutions want to establish a financing arms under the Cap 320, it has to be approved by the Board of Governors. You communicated with the institutions, I believe, yes. Chairman, can I add one more point? The secretary was very clear. I know that the university have to apply for their programs to be approved under Cap 320. The secretary said that they are trying to make things convenient for the institutions, but we must not compromise on the quality. We will monitor the process. As the secretary is taking all the questions, now I will ask the secretary to take a break for 5 minutes because she kept answering questions for an hour. Let's take a break of 5 minutes.